you can prevent the next tragedy. You can save life. You can save families in the process.
California's 30-year-old assault weapons ban, and we have tinkered with this, but
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
That this was bordering on tyrannical. It was an abomination of the legal system that we have here in...
There won't be any immediate change to the law for at least 1 month.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Supreme Court just announced to change CA gun laws. Ammo restrictions case from California. In one of the California lawsuits, Rody v. Bonta, gun owners have been anticipating and waiting for a long time. The 6-3 decision essentially sets a new legal standard for gun laws. Rody v. Bonta. Attorneys for the Civil Rights Preservation Association, or CRPA, showed up in San Diego U.S. District Court at the behest of District Court Judge Benitez to discuss the most effective strategy for the organization's Rody v. Bonta litigation, which challenges the ammunition sales limitation rules that were created by Prop 63. The organization previously had success in this matter when the court correctly applied the logic of the Supreme Court's ruling in Heller from 2008 and granted CRPA's application for an injunction barring implementation of the ammo sales limitations several years ago. This was when the organization already had a victory. However, when the state challenged the verdict, the Ninth Circuit stayed the injunction and remanded the matter to Judge Benitez so that he might examine it in light of the Bruin decision that the Supreme Court announced in June 2022. This was done in order for Judge Benitez to be able to reevaluate it in light of the Bruin decision because it was announced in June 2022. We're optimistic about our chances of success once more because of the fact that the Bruin verdict articulated and enforced a criterion that will be much more challenging for the state to meet than the Heller decision was. However, despite the fact that the Road case is still in the preliminary injunction stage, the San Diego court is pushing for a verdict to be rendered as soon as possible. In the event that CRPA is successful once more, the state's attorneys will likely launch yet another appeal. During the court hearing, the state's counsel made a motion to Judge Benitez requesting that the state be granted an additional 30 days to submit further affidavits from purported experts on the history of the background check and the reasons why this new statute is historically warranted, as is necessary according to the Bruin test. They've been unsuccessful in doing so up to this point, and the judge has expressed skepticism that the state can submit any new evidence at this time. Regardless, the court has given the state 30 days to present its new evidence, after which it will dismiss the case. Additionally, the legal team representing the CRPA will have the option to file new declarations highlighting the ongoing calamity that is California's ammunition licensing system, as well as the ability to provide a response to any declarations that the state files. In addition, the legal team representing the CRPA will have the opportunity to file additional declarations. Landmark gun rights ruling. It's been decided by at least one court that a person cannot be denied the right to own a firearm in accordance with federal law solely on the basis that they're the subject of a restraining order for domestic abuse. A different court came to the conclusion that it's against the law to prevent people convicted of non-violent felonies from owning firearms, and a third arrived at the conclusion that it's against the law for those under the age of 21 to be in possession of firearms. All of these recent decisions by lower federal courts were the result of court rulings that dealt a severe blow to long-standing federal gun restrictions. These court rulings were made in the past year after the Supreme Court, in a landmark decision, expanded gun rights by concluding for the first time that the Second Amendment's right to keep and bear arms extends outside the home. All of these recent decisions by lower federal courts were made as a result of court rulings that dealt a severe blow to long-standing federal gun restrictions. As a result of the decision made by the conservative majority of the Supreme Court's 6-3 majority, there's been a wave of legal challenges to long-standing federal and state rules, which has led some judges to declare that these policies do not comply with the new standard. There are disparities in the legislation all around the country as a result of the fact that certain courts have favored stricter gun control measures. It has also led to blue states introducing a new wave of gun regulations in an effort to avoid being in breach of the Supreme Court's rationale, which has led to the situation. As a result of a lower court's decision that a federal rule that prohibits individuals who are the subject of domestic violence restraining orders from carrying firearms violates the Constitution, the issue is once again on the doorstep of the Supreme Court. The administration of President Joe Biden is asking the Supreme Court to overturn their decision. When the justices decide whether or not to hear the case during a private debate, it'll be the first significant test of how widely the court's conservative majority wants its 2022 rule to be applied. This test will take place on the same day.
She proves you can run for office ending gun violence in the South and you can win.
AK-47 is an automatic Kalashnikov model of 1947.
You can prevent the next tragedy. You can save life. You can save families in the process.
Thought it just like, wow, it doesn't fit the definition, it doesn't fit the rulings, but we better run this up the chain.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
Because they like the outcome of the policy, the banning of a piece of plastic.
In the case of New York State Rifle and Pistol Association v. Bruin, the Supreme Court adopted a new test which states that while determining whether or not a legislation violates the Second Amendment, the justices are merely required to evaluate whether or not the amendment has been traditionally interpreted in a certain way. The conservative majority were concerned, according to its decision in the Bruin case, that lower courts hadn't treated gun right laws with a higher degree of skepticism following the previous landmark gun rights verdict handed down by the Supreme Court in 2008. It would suggest that lower courts, which have recently lent to the right as a result of the appointments made by the previous President Donald Trump, have understood the message this time, given the rapid response to Bruin. Jake Charles, a specialist in weapons law at the Law School of Pepperdine University, stated that as decisions are made more regularly, they're also being made to invalidate statutes that were not previously believed to constitute a major threat to the Second Amendment. Jake Charles is quoted as saying that when decisions are made more frequently, they're also being made to invalidate statutes. Domestic violence claims. In the wake of the ruling made by the Supreme Court, supporters of gun rights have focused their attention on state and municipal restrictions. Nonetheless, the list of federal prohibitions found in Section 922 of the 18 United States Code has become a notable point of debate. One of those clauses, 922G8, protects any person who is subject to a court order as a result of having been found to be a threat to a domestic partner or child. This protection extends to anyone who is subject to a court order. One of these individuals is Zaki Rahimi, a Texas resident who is suspected of being a drug dealer and whose partner obtained a restraining order against him in February of 2020. During an incident that took place in a parking lot in Arlington, Texas the previous year, Rahimi was accused of attacking the woman, pulling her to his car, forcing her inside, and slamming her head on the dashboard.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've gotten a lot of criticism over this. So why is it not a machine gun?
The details of this incident were recounted in court records filed by the United States government. It's also reported that when he realized that someone was watching him, he pulled his gun and slayed the person who was watching him. The federal government claims that Rahimi committed a number of slayings while the protective order was in effect, including one in which he's believed to have used an AR-15 firearm to fire shots into a dwelling. This is just one of the allegations made against Rahimi during this time period. The state had accused Rahimi with both the attack on a household member as well as an additional attack on a different female. Prior to the recent ruling that the Supreme Court made about gun rights, he was charged separately for breaking the federal gun restriction legislation and argued that the case should be dismissed because of his right to bear arms under the Second Amendment. This occurred before the decision that the Supreme Court made regarding gun rights. The claim was dismissed by the federal judge because the statute in question has on previous occasions been found to be constitutional. Following consideration of the case, the United States Court of Appeals for the Fifth Circuit in New Orleans arrived at the same conclusion. After that, the Supreme Court handed down its decision in the Bruen case and made it public. As a consequence of this, the Court of Appeals listened to more arguments before making the shocking decision in March to reverse its previous position and declare that the act fails to pass constitutional muster because of the expansion of gun rights. In court documents, the administration of Vice President Joe Biden asserted that the decision of the appellate court on Rahimi's case was fundamentally mistaken. As a result, the administration had asked the Supreme Court to review the issue. She said that the verdict poses a great risk of harm to individuals who have been victims of domestic violence. Prelogar stated that the act ought to be upheld even when applying the Bruen test, since there's a historical example of the government disarming those who are considered to be a threat to other people. While this is going on, the lower courts are seeing a rise in the number of cases where other aspects of federal law are being challenged. In the beginning of this month, the Third Circuit Court of Appeals in Philadelphia, which is located in Philadelphia, took aim at another section called N22G1, which prohibits convicted individuals from owning firearms. The court ruled that the statute cannot be enforced in its current form in regard to persons who have been found guilty of nonviolent offenses. The court's reasoning was that there was no historical precedent for someone being disarmed after being found guilty of nonviolent charges. This was the reasoning for the court's decision. Similar tendencies have been found in rulings involving other rules, such as those that prohibit those who have been convicted of criminal offenses or who are users of illegal drugs from owning firearms. Federal gun laws targeted. Both proponents of gun regulation and those in favor of gun rights concurred that the Rahimi case should be heard by the court because the Bruen case produced such wildly divergent outcomes in lower courts. William Sack, an attorney for the gun rights organization's Firearms Policy Coalition, stated, "We would be happy to have further clarification from the court on these concerns. It is hoped by those who support gun restriction that the Supreme Court will sustain a majority of long-standing laws like the one at question in the Rahimi case. They would have to decide that those limitations are consistent with the Second Amendment's historical interpretation in order to do so without overturning Bruen." Gaining the support of Chief Justice John Roberts and Justice Brett Kavanaugh is likely necessary for success. Even though he and Roberts were both a part of the 6-3 conservative majority in Bruen, Kavanaugh authored a separate concurring opinion in which he emphasized the limits of the court's decision, making it apparent that the Second Amendment does permit gun regulations. Kavanaugh notably emphasized the ban on the possession of firearms by felons and those suffering from mental illnesses as an example of rules that weren't in danger, citing earlier court decisions. Reconsideration after the Bruen decision. It's one of those things that comes up pretty much every day, so naturally, people have questions about it. A hearing was held recently in front of Judge Benitez, and many of you have been leaving comments and wondering about the outcome of the hearing. As a result of that hearing, we obtained some additional information that we need to cover, and we believe that some of you guys ought to have that information just so that you too are aware of what is happening right now if you aren't already aware of it. The case known as Rody v. Bonta is about the restrictions that the state of California places on the purchase of ammunition, as well as the system of background checks that the state requires before allowing someone to have ammunition in their possession.
The ban on assault weapons happened on Friday, which was also National Gun Violence Awareness Day.
California's 30-year-old assault weapons ban, and we have tinkered with this, but
at all, there needs to be restraints so that those type weapons are not.
There won't be any immediate change to the law for at least 1 month.
This law, which was passed by Proposition 63, mandates that individuals who wish to buy ammunition must submit themselves to either the basic eligibility check or the standard eligibility check, both of which are types of background checks. When you acquire ammo, you're required to go through what amounts to much of the same thing as a background check. Additionally, the state of California places restrictions on the ability of individuals to buy ammo online from an internet vendor and have it delivered straight to their residence. These are the limits on ammunition that are being challenged in the lawsuit known as Rody v. Bonta. When Judge Roger T. Benitez initially looked into this matter, he granted a motion for preliminary injunction by using a version of the text that was influenced by history and tradition. Following that ruling regarding the motion for preliminary injunction, the state of California made the decision to appeal it all the way up to the 9th Circuit. After that, the matter was considered by the 9th Circuit for a period of time and even went through the process of having oral argument in front of a panel of 3 judges. However, after the Supreme Court handed down its ruling in the case New York State Rifle and Pistol Association v. Bruin, the Rody v. Bonta case, along with many other Second Amendment issues in the 9th Circuit, were ordered back down to the lower courts to be reassessed in light of the Bruin decision. Bruin was the case that the Supreme Court decided in. A conference about all of these matters, including Rody v. Bonta, was held in front of Judge Benitez in the month of December. Judge Benitez asked for further spreadsheets and historical material to be shown to him in court so that he could determine what action he needed to take with regard to these cases. He asked that these items be brought to his attention in the courtroom. Since the beginning of February, the majority of these situations have essentially been rather quiet. However, just recently out of the blue, Judge Benitez ordered a combined hearing in the Rody v. Bonta case. That hearing took place last Monday on the 17th, and as a result of that hearing, we were provided with some further information. Judge Benitez has requested information. According to the note in the minute book that was kept during the hearing, the plaintiffs have 30 days from today to give a declaration regarding their Article 3 standing. Within 15 days of the plaintiff deciding whether to depose the expert, the defense must nominate and file an expert report or a statement addressing the history and custom of background checks in the United States. The defendants are required to respond to the plaintiff's rebuttal with either a brief or an expert declaration within 30 days of the verdict. In addition, the defendant is required to submit an updated declaration addressing the acceptance of background checks for ammunition purchasers, /rejection rates and processing times as previously performed within the next 30 days, /rejection rates and processing times as previously performed within the next 30 days from the date of this order. In addition, for the next 30 days from today, the defendant is required to report, to the extent that it's possible to do so, on individuals who were subjected to background checks and were found to be prohibited persons. These individuals were detailed in prior declarations by the defendant. The defendant is required to state whether or not such individuals were brought to justice, as well as whether or not firearms were identified on such individuals and seized from them.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs, are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Consequently, as you look at that, you could be asking yourself, okay, what does all of that mean? It's nothing but a sea of words. In the simplest words, this means that we will have to wait at least another 75 days for anything major to happen in the Rody v. Bonta case. Both parties have been granted extra time by Judge Benitez in order to present further evidence, as well as to answer some of the issues that the judge has regarding standing for the plaintiffs, certain expert testimony and declarations, and simply to clarify some of the questions he had during the hearing. In addition, Judge Benitez adds that the state of California is required to present any evidence that they may potentially have that may suggest prohibited people passed through the background check system were identified, and then whether or not the state of California took action against those individuals. The evidence must indicate whether or not the state of California took action against those individuals, because if there is a system that flags people on a background check and nothing is done about it, then what's the purpose of this law exactly? Now, some of you might be curious about what took place at the hearing, as well as what Judge Benitez had to say about it. A shout out to Cassis Morris, who is one of the CPRA attorneys and who can be found over on Twitter. If you're interested in viewing other information similar to this, you should go and follow him on Twitter, since he's provided a synopsis of what took place during that hearing. He said in his tweet that Judge Benitez had frequently questioned the counsel for the Department of Justice on why they believe outdated racist statutes are relevant to the contemporary background check for ammunition. They stated that while they don't agree with the racism that the law promotes, they do agree with the proposition that there's a long-standing practice of preventing persons who are viewed as potentially dangerous from obtaining firearms. Benitez's dissatisfaction with California's response. Benitez didn't appear content with this response, which is extremely intriguing once more because this is something that we all criticized California for doing when they initially filed those racist legislation in their spreadsheet. Benitez didn't appear content with this response. We're all quite skeptical about that, and we criticize them for providing that kind of historical proof. That also appears that Judge Benitez is extremely critical of the state of California for attempting to utilize racist laws as justification for their ammunition. According to the tweet, Benitez was also unsatisfied with the state's demand for offering expert opinions, and he questioned why the state's historians can better explain historical law with a clear meaning like the discriminatory laws. This was Benitez's response to the state's insistence on delivering expert opinions. In the course of the investigation, the state has broken hundreds of laws, and he is skeptical that there are many more to find. In spite of this, he has allowed them 1 month to provide expert declarations, most likely to prevent the Ninth Circuit from sending it back to him for further consideration. Again, this is something we mentioned where a lot of people have been wondering why they gave them additional time to submit these spreadsheets in December, and why now they're potentially giving him more time. And the reason for this is simply because the state of California has been signaling multiple times in their briefings that they will try to raise that there were some sort of procedural issues with the decision that was made by Judge Benitez during the appeal process. Because the judge understands that this decision is going to be challenged on appeal, all that Judge Benitez is doing here is attempting to plug as many of the gaps in the argument as he can.
Their case to then pay the state's legal fees, which could run into the millions. It's a stipulation that Judge Roger...
That this was bordering on tyrannical. It was an abomination of the legal system that we have here in...
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
In addition, it seems that standing was a significant topic during the hearing, as Judge Benitez spent a lot of time discussing the topic. The state of California is arguing that the individual plaintiffs don't have the legal right to file this lawsuit. Costas mentioned that he had an interesting exchange with Judge Benitez, during which the judge discussed how he used to go bird hunting in Arizona and would frequently buy extra ammunition while he was there. The state of California is challenging that the individual plaintiffs have the legal right to file this lawsuit. If he didn't use those rounds, he could decide to bring the rest of them back with him. If that were to happen, would the state of California require him to visit a California gun store as soon as he got back to perform a background check on the ammunition? At this point, it's reported that Costas actually corrected Judge Benitez and explained that if he crossed the state boundaries with the ammo that he brought in Arizona, he would actually be in violation of this law. This is because he would be transporting ammunition across state lines. In order to complete the procedure, he would need to transport the ammo from Arizona to California, where it would be received by a California FFL. He would then pick up the ammunition from the FFL and continue with the process. It would appear that this fact and this reality caused Judge Benitez to become more irate and even more dubious of this law that's being enacted in the state of California. It's also reported that Benitez gave the impression that he would have no problem with a background check in the manner that Proposition 63 had originally envisioned. It was described as he believes Bruin's footnote 9 would permit that type of scheme. However, that's not what California actually implemented. Instead, they changed the law to make it something that would be more complicated than something like an objective test that is even mentioned in Bruin. These are a few of the most important takeaways from Bruin's analysis. If you're interested in more details, then go ahead and follow them on Twitter. It would appear that Judge Benitez was, as is custom, extremely fair to both sides of the argument, most notably the pro-2A camp and the CPRA in the state of California. However, what this actually implies for the typical local person is that this will take some time, and we won't see any substantial movement in the situation at least until October of this year. Well guys, that about does it for this video. See you next time.